Mr. West?
Yes, Judge Higginson, Gaines West. I'm here representing Austin Van Overdam.
Hello.
May I proceed?
Yes, you may.
Thank you. The last time I appeared before then Justice Willett was in 2017 in the Texas Supreme Court, and I was arguing a case that reminds me so much of the issues that we're dealing in this dynamic area. It's so dynamic, we filed a letter yesterday bringing in two new cases that I'll discuss briefly. But in that 2017 case, it was a med-mal case. I think Judge Willett will remember it because I was about 8 minutes into my oral argument, and we had a DPS trooper that locked his legs, and he fell over and cracked his jaw and knocked himself out. And we recessed, came back, and the clerk, Blake Hawthorne, said, Gaines, are you ready to go? And I said, ready to go for what, Your Honor? I mean, really, to the clerk. And he said, well, the court's ready to go. So I had 8 more minutes. But Justice Boyd, I don't know if you remember, Judge Willett, was questioning me on this issue of the 120-day report and whether there ought to be a causation standard, kind of an MSJ standard. And it relates in this way. From a policy standpoint, I saw that come up again when I filed these cases, this latest case, the Sanford case, Doe v. Sanford, in that what the courts seem to be doing in the application, or some courts, the 11th Circuit here, seem to be doing with the application is to bring in the Iqbal Twombly standard to shave away at this simple rule that was established in Purdue. That rule in Purdue is simple, it's administrable. The question is, general question is whether or not A&M in this case was motivated by sex bias in disciplining my client. In the med-mal context, we had an announcement in my case. I didn't make good law for the plaintiffs, made bad law for the plaintiffs there, in that Justice Boyd added a requirement that there be a causation standard way early in the process in this 120-day report. What happened, though, in the cases that followed my case over the years, they've had to back up from that standard because there isn't enough evidence. You can't get evidence at that stage. Just like here, you can't get evidence to bring forward because this is all circumstantial evidence, mainly in these cases. But here's something else I've never heard mentioned.
I'm going to interrupt just because your time's ticking away. It was certified, but I'm confused as to what the adverse order is that you objected to that supports the first question certified.
Sure. And we're here because not only did Judge Ellison certify us, but you all agreed to take it up. But you might think, well, what are we here because it's a discovery issue? It's not really a discovery issue. It's more of a claim preclusion issue because we were in the process of discovery, and the state had Judge Ellison agree that the use of limitation was upon us, and he was struggling with the facts, trying to decide which corral to put the...
But he never restricted, there's no discovery order that's been issued.
Well, we went in for a motion to compel, and he was struggling with those issues, and that's why we took what I argued to Judge Ellison and said, Judge, what you're doing is you're trying to decide which corral to put me in the USIF categories, and that eliminates some claims, and I need to discover it completely and fully.
Okay, so, see, here's my problem. As far as I can tell, the Purdue framework, which I think all courts are accepting, and I don't think is inconsistent, which is your argument in the brief. It's not inconsistent with Plummer and Clark. But you knew it, and you charged erroneous outcome and selective prosecution.
Actually, we didn't. If you'll go back and look, the reason we charged it the way we did, or the reason we pled it the way we did, was Plummer, came out in 2017.
Yes, I know Plummer well.
I know you do. And then we had Purdue that came out in 2019. Correct. As soon as Purdue came out and we saw the 3rd, the 4th, the 7th, the 8th, the 9th, the 10th, the 11th, the DC Circuit.
Did you move to amend?
Yes. And, well, what we did is we came in and asked the judge to consider the briefing issues because the state said that the use of corrals reduced our ability to discover.
But you had pled the use of categories.
We had pled the use of categories.
And then in the November hearing, well after Purdue, even in the motion to reconsider hearing, you keep telling Judge Ellison that you're making those two manner and means arguments.
Well, we did because, you know, our pleading time was past. We couldn't re-plead it at that case. And, you know, the other thing
What's the difference?
I was about to say...
What is the difference?
Yes, Judge Hill.
I'm sorry if I'm interrupting.
No.
I'm not sure I understand where
Yes, Judge Hill.
these answers. What is the difference between... You've alleged two claims, or at least originally, right? Erroneous outcome and selective enforcement.
Well, those are the two claims that really apply out of the four claims out of the USIF.
Okay. And I assume your theory is erroneous, the reason the outcome was erroneous is because of sex discrimination.
Yes.
And I assume the reason for the selective enforcement is sex discrimination.
Yes, and that's
so what is the difference between these standards? I see none.
You know, there is none, and I think so.
Why are we here?
Ellison was dealing with that.
Why are we here?
Well, why we're here is because the state of Texas convinced Judge Ellison to limit us to selective enforcement and not erroneous outcome.
I thought that was your theory.
Pardon me?
I thought that was your theory.
It was my hearing, but...
No, your theory.
We had two theories, but he limited us only to selective enforcement, not to erroneous outcome. And what we asked for is...
So what are your... I'm assuming what the district court did is determine that there wasn't a sufficient pleading of sex discrimination. What is your best pleaded fact to support a theory of sex discrimination?
Our best pleaded facts, at least five, which...
Let me just give you an example. Because in Purdue, among the other facts, there's this theory that the university put out this statement that sexual assault is not caused by alcohol, it's caused by men.
Yes.
Right? That is evidence of sex discrimination. What is your best evidence of sex discrimination as opposed to anti-rape here?
Right. I have at least five. I have more in the brief, but let me cover these five with you. You remember we named the acts 1, 2, and 3. We figured it was better to do that than to go through all the really detail of those issues. But Act 2 and not 3 Act 3 was non-consensual, it said, but Act 2 was non-consensual, and Act 3 was consensual, which we believe will lead a reasonable majority to conclude that was motivated by a gender bias. Act 2, pardon me?
You're telling me that somebody was found guilty of an offense. That is not evidence of sex discrimination. What's the evidence of sex discrimination?
We believe the evidence of sex discrimination is that the result of those findings would lead a reasonable jury to believe that gender discrimination was involved because the conclusion that Act 3 was not consensual, or consensual rather, and Act 2 was not consensual, is incongruous. They don't go together. And because they don't go together...
I mean, that's exactly what you said on November 5th at the hearing.
Yes.
So it's consistent. You say it's impossible to come to the conclusion that a female would refuse Act 2, sodomy, yet consent to Act 3, fellatio. But where is there sex? What Ellison said is, okay, that's a clear, specific theory. You've defined your theory. But as to that one, I don't see any gender discrimination.
May I go on?
Yes, of course.
Reasons.
No. The reason as to that. Where is the sex discrimination in that?
We believe because there is a front-loaded bias towards a man that they're going to find sex...
Do I understand correctly that Act 2 involved a physical holding down of the woman by her wrists? That was Act 2, right?
That's what the panel found.
The allegations, right? I'm not asking you to stipulate to the fact. Act 3 was not that physical involvement. It was more she felt like that's what he wanted.
No, she said she changed her mind, and she said it was consensual. And
you're right to remind me. So if the if the school found that Act 2 was a violation and Act 3 was not a violation, and you've got this very different fact pattern. One involves physical coercion, the other involves an admission of consent. I am not hearing how that difference in outcome is a story of sex discrimination.
If you'll take all of these acts together, like the second reason would be that Act 2 was determined to be non-consensual, but yet they found him not to be liable for dating violence. That again makes no sense. Number 3, I represented.
It's not consensual, but
it didn't result in a finding of dating violence. So
why is that a story of sex discrimination?
Because it's incongruous that you would have that finding, or we believe a reasonable jury.
There are a gazillion Title VII cases that support the proposition that just because an employer may not make a good decision doesn't mean they've made a racist decision. How is this sexist?
May I go on to the third, and if I go through all 5
I'm going to take that as admission that the first factor is not a factor at all. Go ahead.
All right. The third factor is that I actually represented a female in a case that was almost the identical fact situation, and I had a representative of the General Counsel's office on the phone at that hearing who admitted that they gave a lesser sentence to that female as a comparator than to my client.
Right, but that's the one that you told the district court that is, quote, this is a selective enforcement case.
I did.
So that third factor, he agreed you had some evidence of sex.
He did. Okay. But also we have the Aggie ring issue. They claimed that their panels, we had affidavits from attorneys that we brought forward, that some attorneys that also appeared before A&M said that their clients were berated because whether they were worthy to wear the Aggie ring or not. They were also given unequal assistance. The complainants were given unequal assistance, and in this case, Ms. Shaw was told she didn't need to testify about former hookup experiences. She didn't need to testify about her experiences with mental health providers. Taking all those 5 together, we believe that it will show.
Aren't there a lot of rules of evidence that specifically exempt that kind of evidence in this context of sexual harassment?
Judge O, here's the problem. We're not at the evidentiary stage. This is not an MSJ case. This is the pleading case, and this is the problem.
Right, but we're trying to get an inference of discrimination.
But this is the problem with the Sanford case, Your Honor. And I've never heard anybody talk about this before, but I've stood in the well of judges like Lynn Hughes in Houston and Lee Rosenthal in Houston, great jurists, that have me explain with reasonable certainty the investigation that I've done into the evidence. I've got an 11B standard that I have to live up to. And so these are circumstantial evidence cases. That's what they are. They're not direct evidence cases.
But Sanford, you bring up Sanford. The 11th Circuit said the use of categories are still legitimate manners and means.
They did, but they also adopted Purdue, but they also used Iqbal Twombly to be able to prevent the litigant from moving forward, the plaintiff from moving forward. And I think that's the danger here, and that's what we shouldn't get into, because the Doe v. Princeton case, it was decided just last Thursday. Judge Mady wrote that opinion. He did a great job by saying simply, look, what we need to do is pay attention to where we are in this process. We're in the very first process. You know, we also have in our jurisprudence in Texas, I was on the Board of Disciplinary Appeals for 11 years. And in our grievance system, we have a disciplinary rule of professional conduct, 8.04A3, that is now being held against people like General Paxton for signing on to documents and being filed someplace, and grievances are being brought for attorneys who are simply signing on to documents and making arguments. That's the same kind of problem I have here. When I plead a case, I have to be sure I know my evidence, and I plead the evidence that I have, but Judge Mady was right. What we need to do is allow, once we have pled the evidence that we have, be able to go forward in discovery. If we make it, if we prove it, great. If we can't, then it'll be taken care of in an MSJ context.
One fact question, did your client submit any questions to the panel to ask Ms. Shaw?
I didn't represent my client at
Do you know the answer to the question?
I don't know the answer to that question, but I believe, Judge Higginson, that they did not. And one of the problems that you have in this area is that I see my time.
No, of course, finish.
Okay.
Yeah.
One of the problems you have in this area is that you have issues of liberty interest at stake, and putting the person who is being alleged to have conducted these activities in the position of having to give questions, talk to the panel, and it also takes the panel out of the position of being an impartial arbiter of the issues to have to ask those questions. That's why the second point was we want to have cross-examination.
You have time for rebuttal. Thank you, Counsel. Ms. Cherry?
May it please the Court, Kathryn Cherry representing Texas A&M. So I'll just go through my introduction, and if it works out, I'll go and answer some of the questions that you asked opposing counsel. So Van Overdam was found not responsible for 3 of the 4 counts of sexual misconduct before the hearing, and yet he alleges that the hearing panel was biased. But none of the allegations in his complaint make that a reasonable inference, or make a reasonable inference out of the facts that he alleges. Also, he asked no questions of the complainant. You can actually find that at record site 2084. During the motion to dismiss hearing, they talk about that a little bit. But he nevertheless claims that the university deprived him of due process because of who was asking the questions. But under this court's precedence, if you have a respondent in a live hearing and they can confront the accused, they can submit questions to a neutral panel, and that panel can ask the complainant that satisfies due process in most cases.
He was allowed to do that here?
Yes, so he had submitted questions. That's how it would have been, and he actually had an attorney.
You're saying he didn't even try?
Right, he didn't. So he had an attorney.
Even to the committee?
I'm sorry, so.
He didn't even ask the committee to ask questions?
No, so he had an attorney beside him, and then he was sitting there. What he could have done is his attorney could have written out the questions, given it to him. He could have submitted those questions to the panel. The panel would review them for relevance. I think they also take out questions that are for like humiliation or something like that. And then the panel asks the questions of the complainant, Ms. Shaw. And at the same time, while Ms. Shaw is answering and the panel is questioning, the respondent would hear the questions and the answers. So while they didn't have enough time to say, submit one question, ask one question, submit one question, ask one question, you could, they kind of had an unlimited opportunity to follow up. So he could hear her answer to one question and then go back and say, okay, here are 3 more questions that I want you to ask Ms. Shaw, and pass them that way.
Why shouldn't we adopt the Purdue standard? It seems pretty obvious from the text.
Yeah, I think that the whole Purdue-Yusuf split dichotomy is a little bit of a red herring. I think that—
Totally agree. It seems to be the same standard.
Right, so Purdue is just saying, follow Title IX. Yusuf is saying, follow Title IX. Here are some examples of how you can make those claims. So even the cases where they are adopting Purdue, they're still using Yusuf for examples of, well, if you want to make this kind of claim, here are the types of things that you might want to allege.
Okay, so the state doesn't have any problem, or the university, I should say, doesn't have any problem with us applying Purdue since it's the same thing. Right.
I mean, it's not even necessarily clear what Purdue is saying other than look at the statute, which is what we would do anyway. And Yusuf did the same thing, right? They said, look at the statute.
Right. Purdue, Yusuf is just applying Purdue to specific fact patterns,
right.
But it's all about sex discrimination.
Right, right. Okay. And that's what Purdue said about Yusuf, and that's what Yusuf said about Title IX.
Okay. So is there anything groundbreaking then from your standpoint about applying Purdue?
No, Your Honor. If the court wishes, I can go into the specific examples that opposing counsel discussed that he said supported sex discrimination. Unless there are any other questions, I'll just go through them.
You don't, so you, in agreement, I think, you don't see any split out there among the circuits.
Right, so we don't think that you toss out Yusuf. We don't think that you toss out how to allege.
Can you look at this record and say that the district court somehow applied a more rigid pleading standard, though?
No, Your Honor. No.
Okay.
It was just, no, Your Honor. It's kind of the Iqbal Twombly standard, and then the elements of Yusuf, which would be kind of a common sense way of proving that there was selective enforcement or that there was kind of a...
So after Purdue, we have 2 hearings here, right? At least 2. The November hearing and then the motion to reconsider.
Yes.
And at that point, the use of categories are still being used by everybody.
Right.
And then the district court dismisses one theory, manner and means, but not the other.
Right.
So what do you understand the issue that this is asking you to help me? What did we certify as to that issue? What's the issue before us? Was any discovery limited yet?
I don't know about the discovery and kind of the course of discovery. I believe that opposing counsel is implying that discovery was limited in some way, but as far as I know, just based on kind of the complaint and the cases, the only issue is what were the facts alleged and how to prove them. And so the district court basically said, well, you didn't prove that he was investigated or that his sentence...
Plead.
I'm sorry.
He didn't plead, right?
Yeah, he didn't plead, you didn't, you made kind of a possible argument that maybe you would be able to find through discovery some evidence that his punishment or sanction or sentence was influenced by bias.
That's because opposing counsel said he represented a woman who'd been punished less. That's the selective enforcement that's going forward.
Right, and I think he had the affidavits, which we would say are very conclusory and don't really show how these folks are similarly situated, but that is what the court said. You might as well just go forward on that. You might find something else. But as to saying that the result of the hearing itself was due to bias, he wasn't able to allege sufficient facts to support a reasonable inference that that there was any bias that affected that. And so that's what the district court said is, this way that you wanted to prove that there was...
Maybe it would help to go through the facts that he says show bias as to that manner and means.
Sure. So I think that the first point that he raises is this anal intercourse would not have been followed by oral intercourse if the anal intercourse was non-consensual. My view on that is that that's actually applying the archaic assumptions that Title IX is supposed to prevent schools from applying, as in what you're saying is, here's what a woman should have done after she was abused, right? And we know in domestic violence situations, for example, that you really can't say that it's unreasonable for a woman to have, X stay with her abuser or continue the conversation or anything like that. And moreover, in the pleading itself, and I think it's at paragraph 18 or 19 of the complaint, the respondent says she was afraid, right? So it would make sense if you wanted to kind of infer, right, that it's not no reasonable jury or no reasonable fact finder would find. It would make sense that if she were afraid, she would still engage in this intercourse. It would also make sense that there was no indication for Van Overdam to understand that that was the case. And under Texas A&M's rules, you have to know or have some indication or should have known that you were doing a non-consensual act. So it's not as if it's not as if we can presume just because the panel found that he was not responsible for the oral intercourse that it was entirely consensual. It was entirely consensual, right? Or that it's just isn't logical to follow after a non-consensual anal intercourse. For the other, I think another thing that he kind of talks about is the panel's intervention in some of the parts of the case. So first of all, if the intervention is, he's trying to testify about her mental health and she begins to testify about Tinder, the panel interrupted both parties' testimony, so they were being treated equally as in the panel was intervening. And also, those are the exact types of evidence that cause the most problems in these kinds of cases. And so, for example, under kind of Texas Rules of Evidence 412, that's about prejudicial sexual history. Texas Rule of Evidence 510, which is about mental health records, it doesn't show bias for a court to be wary of that information coming in. And because this was a hearing where it wasn't already discussed whether or not that evidence would come in, it also makes sense for the panel to kind of intervene at the outset, right? Because they didn't have an argument for why this was relevant or what exactly the parties were going to say about the evidence. And also, I think that Van Overdam makes this argument that, judges shouldn't be kind of intervening and asking questions like the panel was, but of course, there's like voir dire and like competency hearings, and I think even under Federal Rules of Evidence 103D, the court is supposed to protect the jury from inadmissible evidence. So there's plenty of cases where judges do intervene in order to protect the jury or the witnesses or just under state law. And I think another, right, we already kind of talked about the affidavits. We talked about the sexual history. I'm just trying to see what.
Do I understand at the end of the day, we're not being asked by either side in this appeal whether each claim should or should not proceed to discovery and trial? We're simply being asked, are we applying Purdue or USEF? And the answer is both, presumably.
Right, so the discovery question is not before the court.
We're not here to test whether these claims survive. We're here to answer which standard applies.
Well, the motion to dismiss order included dismissing this particular claim as he pled it under USEF. And so
I think the order is here, but isn't the question presented on interlocutor appeal just, do we apply essentially the Purdue standard? Or am I misunderstanding?
Yeah, so I would say because the court granted the order, and that was part of the order, was dismissing this kind of unfair offense claim or the claim that the hearing result was affected by bias, that we would ask the court to affirm that. And the ground on which the court could affirm that is there's really no difference between USEF and Purdue, or the court was correctly applying just Title IX, right? But that was part of the order, as well as the dismissal of the due process claims.
I see. Okay.
Is there more to say on the due process argument beyond your briefing?
I don't think so, Your Honor, but if you have any questions, I can. Okay.
Thank you, counsel.
All right, thanks.
Rebuttal?
Thank you, Your Honor. I wanted to point Judge Ho particularly and Judge Higginson to Doe versus University of Arkansas. We cited this in our brief, where the student accused male was found responsible for sexual assault but not expelled, which my client was not expelled. Because the hearing panel explained it was a close call, unusually light punishment can support a claim of sex bias. Also, in Purdue itself, it says a perplexing basis of a decision can support a sex bias claim. We have perplexing decisions in this case.
And what are
in
those?
Doe versus,
What are those?
those would be the Acts 2 and 3, and certainly Act 2 not being dating violence, although it was a claim where there was alleged holding of hand down so they could complete the act, the unequal assistance of one party or the other.
I apologize, because I'm just not understanding. Why is it that finding a violation in Act 2 but not in Act 3, there are two different acts?
They are two different acts, but they followed one right after the other. Every person I've asked, male or female, has said that you can't have Act 3 happen if Act 2 was non-consensual. And that makes it an inconsistent type finding that a reasonable jury could determine led to sex bias. And we have Purdue saying that very thing, that if a perplexing decision comes out of that, that's enough to support.
I thought Act 3 was not considered consensual. I take your point is, having been a victim once, you're not going to come back and consent.
Amen.
But I don't understand that to be even the fact. I'm not going to get into whether that's true or not. I'm not sure that's actually true. But putting that aside, I thought Act 3 wasn't consensual. It may not have been a violation, but it wasn't.
Act 3 was consensual. She admitted it was consensual. She changed her story. Act 2 was non-consensual. Act 3 was consensual. That's what makes it perplexing. We have Doe versus Miami University. The unexplained discrepancy in findings supported a claim of sex bias. So it is these explainable findings that wound up getting us where we are. Judge Ellison had difficulty, and you can see from the record.
I understand that Act 3 was done out of fear, so I see that. I mean, the word consensual can.
She claimed it was done out of fear, and then she changed her mind. She said it was consensual.
What's the record cite for the change of mind?
I believe it's either 567 through 573, I believe is the record site.
I think that's kind of around the part of your second amended complaint, but beyond what's in your amended complaint, I'm not sure what else there is in the record confirming that she changed her testimony or...
It was in the hearing. I didn't memorize that particular record site. I can get it for you. I'd be happy to supply it post-briefing, but she changed her mind so that Act 3 was consensual, and that's what makes it a very unexplainable event, a real problem. Judge Ellison stated in the record at the motion to dismiss hearing that we could not get into erroneous outcome evidence and discovery. And here's the problem. You say, are you simply asking us to apply Purdue, and what's the difference between Purdue and Yusuf? There's a big difference between Purdue and Yusuf, because Yusuf creates confusion. Yusuf, you have to corral two areas, put evidence. You have Judge Ellison is sitting there trying to figure out, does her change of mind for Act 3 now, does that make it an erroneous outcome, or does it make it selective enforcement? It's very confusing. The wave of the future, and that's why the 3rd, 4th, 7th, 8th, 9th, 10th, 11th, and the D.C. circuits have gone with Purdue, is it's an easy standard, and that's what Judge Mady said. Judge Mady said, look, you get in here, you plead what you know, and that's what we did, and then you get to go discover it, and if you make it, great. If you don't, then at summary judgment, you don't make it. What we did was plead what I could within the constraints of 11B and 804A3 and the disciplinary rules of professional conduct, and now all we want to do is get complete and full discovery under Purdue, the holistic theory, rather than the corral theory.
Anything more to add on the due process?
Sir, I'm sorry?
Anything else beyond your briefing you want to say about the due process claim?
I think the due process claim is a claim that we believe the current law, as it is drafted, I'm sorry, I'm out of time.
Of course, continue.
Thank you. The way the current law is drafted is that we get cross-examination, and it should remain. All we're asking for is a name-clearing hearing. We've got the state of Texas who has present briefing before the Texas Supreme Court saying that they can revoke degrees out of two state institutions. So we know that they do have the ability, they think they have the ability to do this. So thank you very much for time.
Let me briefly follow up. So I want to make sure I understand this Act 2, Act 3 theory. Your theory is Act 3 was consensual.
Yes.
Therefore, Act 2 could not have been non-consensual.
We think Act 2, we believe all three acts were consensual.
Right, but your point is Act 2 must be motivated by the action based on Act 2 must have been motivated by bias, because Act 3 was consensual.
If you take Act 2,
therefore Act 2 had to have been consensual.
If you take Act 2 and Act 3 together, we believe it was bias. Thank you, Your Honor.
Thank you, Counsel. That concludes the case for the day and for this sitting.